Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about is how to file a motion to quash in a family law case. So a motion to quash is basically a motion asking the court to invalidate a subpoena. So a subpoena is a document ordering somebody to appear for a deposition or appear in court. So allow me to share my screen. I will show you the relevant practice book section. So Connecticut Practice Book section 13-28 has to do with depositions and subpoenas to depositions. So if we scroll down to subsection E, it says that the court in which the cause is pending upon motion may quash or modify a subpoena if it is unreasonable and oppressive, or if it seeks the production of materials not subject to production under the provisions of subsection C of this section. So basically, if it asks for documents that are not subject to normal discovery. So, a motion to quash is, it's basically you're saying this subpoena is asking for something completely unreasonable, or it's asking somebody to come to court on unreasonable terms. So it's basically trying to eliminate a unreasonable deposition or subpoena request. And these are often filed on behalf of third parties who are not a party to the case. So in the context of a divorce, it may be, the boyfriend or girlfriend of, one of the parties, the person they're having an affair with, or maybe an employer or some other person who is connected to the case, and the opposing party wants them to testify at a deposition or at a trial. So I'll show you a sample motion to quash. And again, these are often filed on behalf of third parties. So you're going to put that pursuant to Connecticut Practice Book section. So you're going to put that pursuant to Connecticut Practice Book section 13-28, which is the section I just showed you. The undersigned on behalf of, and then insert the party's name, so the third party witness usually, a non-party to this action who has been sent a notice of deposition with a subpoena for documents hereby moves to quash the subpoena. In support of this motion, third party's name represents the following. So then you're going to insert an explanation for how the subpoena is unreasonable or oppressive, or how it seeks the production of materials not subject to production under the practice book. So you can put a little bit of a narrative, but you may want to explain that, the subpoena is on short notice. Maybe they subpoenaed somebody 2 days before, the deposition, or even a week before, that it hasn't allowed the third party witness to make arrangements to be there. Maybe it's overly burdensome for them to go to the deposition at all. Maybe they're not able to attend on that particular date, or maybe there's some overly burdensome request of documentation. They're asking for bank statements when this person has nothing to do with the case. So you're going to want to put the explanation, and then below that, you're going to insert an explanation for the relief you're seeking. So you may want to quash the subpoena, so that they're excused from attending altogether. You may want to quash the Schedule A, which is attached to the subpoena. That's the document kind of listing all the documents that they're asking the person to bring to the deposition. So you may want to eliminate the need for them to produce documents. Maybe you want to limit the scope of the deposition to certain topics so that the opposing party can't just use it to annoy everybody. They often will do that. That can happen where somebody just starts subpoenaing witnesses just to give the other side a hard time. So, you can ask that that person not be brought in at all, or that the deposition be limited to certain topics. You might ask for an award of attorney's fees so that the person, so that the third party, doesn't have to pay for their own attorney to get involved in this case that they have nothing to do with. Or, you may want to ask for more notice to reschedule the deposition to a later date. And then generally on all motions, we put any further order that the court deems fair and equitable. So those are the basics. So you're going to want to do a motion to quash, particularly with a third party who is subpoenaed to a deposition. If it's a subpoena to court, you're often going to want to, also include in the motion a motion for protective order. And there, I've done a separate video that talks about filing a motion to protective order. So you're going to want to check that out too if you are doing a motion to quash, particularly if it relates to an appearance in court. So those are the basics on a motion to quash. As usual, if you have any additional questions, feel free to contact our office. And if you are seeking representation in a family law case, we'd invite you to contact our office to see if we can be of any help to you.